Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Oh, look, there. I always have us on the wrong thing. There we are. Hello, everybody, and good morning. Happy Tuesday. It's Tuesday, St. Patrick's Day, and we're here. We're here a little late. I had another show before this for members, but I'm here. Apologies for Friday. We had to cancel a show Friday because I'm also a mom, and sometimes mom duty unexpectedly calls. So that happens, and trust me, I would have much rather been doing my streams that day than all the mommy stuff I had to do. So, but we're here today. Man, I can't wait for summer. I can't wait for summer.
But is it a real child?
Is it yes? Oh, yes, it is. It is real. It is 14 years old. So
and I need to see photos.
You need to see photos of little Llama. I'll tell you what, yesterday was even another crazy mama day. After he was supposed to be home at 4. Okay, that's when his bus gets here. 4:45, he's still not home. And his phone isn't on. I was losing my shit. Okay.
That's way too much true crime for that.
I know. Well, I spent the whole weekend writing about 17 people that went missing and then was murdered. And I'm like, oh my God, where is he? You know, because his school is only like 5 miles away from my house. It's not, I was checking like Google traffic, you know, because I'm in the city, and there weren't any accidents. And I'm like, what is happening? His phone is off. Like, oh my God. Right. So like I called the school, nobody's there. And then I had to call the bus barn, which is a nightmare to get through. It really is. And they were like, well, they do have a substitute driver. And I was like, okay. And I was like, but like, because it wasn't the dispatch lady. And I was like, well, like, is the bus back? Like, what, like, where is it? You know, because there's literally like 12 kids that ride his bus. So it's not like it's a whole thing. And she was like, well, it's still out right now, and I'll send a message to dispatch and they'll call you back with an update. This is at like 4:45. And I'm like, okay. Well, that makes me feel a little bit better to know that the bus is still out there. All right. That he wasn't just like kidnapped outside my window, you know, and they don't call. So it's then 5:36. And he's still not home. He walks in the door at 5:36. And that's when they call me to tell me, oh, by the way, your son should have just gotten off the bus by now. And I was like, yeah, he just walked in. Yeah, I've been waiting for a call for like 45 minutes.
Well, that's not helpful.
No, like, because, right.
I was curious about, like, I needed that answer or something like half an hour ago, 45 minutes ago.
Because we were like seriously about to call the police, because we couldn't like go look for him, because we had also scheduled a huge delivery for groceries, and like coming any minute at that time. It was just, oh my God. And let me tell you what, it was the most, that hour, I was just a mess. Could you, oh my gosh. Hi, Terry. Hi, Chad.
Well,
I see Chad's been
that
busy.
happened to me once, but the bus got into an accident.
Oh, well.
And that was, yeah.
Because normally if the fast fashion, normally they'll send out a message like the bus is running 25 minutes late or whatever. No, none of that. None of that. So it was crazy.
Well, they put trackers on our bus now, so I can see where it is.
Oh, really? See, we don't do that because it's kids. So that's interesting that they knew that. Anyway, good morning, everybody. We are here to talk about some more Laura freaking Owens. Thank goodness, because she makes me feel so good about myself.
Laura freaking Owens.
Mom duty does happen. Yes. So that was a fun day yesterday. Today, I don't know. We'll see how today goes. It already started not great at like 4 o'clock in the morning with my dog. So we'll see.
Oh,
and apparently in Ohio, because that's where I live, there was a big boom at 9 in the morning. Like the whole state heard it, and it was a meteor It's towards Cleveland.
No
Yes.
way.
Yes way. It broke like the sound barrier and everything. And like people down in Cincinnati, because I know you're not familiar with Ohio geography, but Cincinnati's at the bottom and Cleveland's all the way at the top. And you could hear and see it like go to Cleveland. So that's what kind of day is. I don't know what color it was.
I didn't get that text message alert.
You saw that too? Did you
No.
see it in Texas or just the news? Huh. Yeah, so
Crazy.
that's a day. That's a day already. But anyway, so we're gonna go over some more of Laura Owens versus Greg Gillespie documents today. Oh, you're in Colorado. Oh, from the news. Okay. Okay. Yeah, it was crazy. So they tried to get the case dismissed before they had to take it too seriously because they were like, her claims are bullshit. All right. They accuse her of fraud. She goes back and accuses them of fraud, extortion, all the stuff that she was actually doing. And the judge was like, yeah, we're not going to dismiss the case. So now Greg's attorneys have come back and like, all right, well, let's play some fucking ball then, because we are trying not to do that, but we have no choice at this point. So that, and we're in the year 2022 at the beginning, February 2022 of this case. It goes on for quite a while. So that's what we'll be doing today. And I don't know. We'll see what it brings us because I didn't really read over these ahead of time. So I just glanced.
Oh, good. So we're both going in like, what the heck?
For these, yes, kind of. There was one big one that I had scheduled today, but I did look, and the exhibits were all the same ones. Nothing new in any of those. So that was annoying, but that's okay. We got plenty to talk about.
Send me new stuff.
I'm so glad we're talking about Greg too, because this is the one where like I'm really unfamiliar with the storyline, you know, and all of that stuff. So I'm excited.
Oh, I forgot to tell you. So over the weekend, talked my husband into listening, not to this, but to the Love Trap podcast. He listened to the first 2 episodes with me, and then he stopped. And then I walked in the house the other day, and he was listening to episode 4. So he was listening to it without me. And I was like, okay, now that you got your toe dipped in, watch my show.
Right. Come watch us. Come watch the Real Crazy. Paul. Jesus Christ, Paul. No, that's awesome. I felt like he would be into it too.
I know. He's like, what? The rant, because we had a long drive to my father's house. So it was so fun. And I was like, okay, but this doesn't even cover, like, you gotta read the emails, bro.
Right? Like it's something. I know Elbow Feet's gotten into it too. And I'm like, yeah, I know. It's crazy. It's absolutely just.
No, it's like, you gotta read it. So.
All right. Where's the one that puts us on stage? I think it's that one. Or is it this one? Oh, that's the one that covers our faces. We just click buttons. We do. We just click around, whatever works. We are professionals. We're about as professional as Laura is. Because remember, she's a professional podcaster and internet personality. So we're going to claim that too.
Okay. I'm putting that on my bio.
What's the name of the podcast, Kelly? Love Trapped. Yeah.
It's very good, but it's mostly about Clayton.
Right.
And that's what I was trying to tell him while I was talking, like, but there's other guys. I was like, you got to go back to the beginning.
Yeah. We got to go back, as Jack said in Lost.
You have to go back. There's more. There's more.
So much more.
So it's so funny.
Well, I love
and
that.
Then it was like, him. And of course, I'm like talking, and he's like, just stop. I gotta figure this out, and then we can go back. It's like, I don't even know what's happening yet. It's so funny.
It is. Anyway, I love that. I love that for you guys. Because I just love that you can rant to him about true crime stuff sometimes. So you're starting a Justice for Zoe campaign. Screw her.
He's the one that got me into true crime. Believe it or not.
Yeah, they do. They do mention some of the other guys, but just this season about Clayton. Oh, is that, are they going to try for a season 2? I mean, you kind of have to, because it's really just, oh, Greg declined to participate in the podcast. Honestly, that's understandable.
I don't blame him. He's like, no.
To be in these court cases with her for years, like, you might need a break. I would.
Yeah.
We'll need Mr. Buffy. I know. We need the misters of True Crime and Wine Time. We need Mr. Buffy. We need Elbow Feet.
This stream would get like censored, like banned so fast. The words that come out of his mouth.
I don't know. I've been pretty spicy lately. I'm not sure. All right.
So colorful.
Very colorful. Now, so this first document isn't really much of anything word-wise. Okay, it's literally like 1 page. All right, but this is their stipulation to dismiss plaintiff's Title 13 claims, which is, as they'll say here, this is Laura stipulating to dismiss her claims based on criminal domestic violence statutes. So she's saying, all right, fine. I'll stipulate that we're not gonna do that. We're not gonna talk about it. But only as no private cause of action exists based on the criminal statute. So the fact that they got her to stipulate anything, honestly, was surprising to read.
So basically, it sounds like she's like, okay, I'll dismiss it only because I did it wrong.
I think so, yeah. But we know she's probably going to bring it back. She always does. So, you know, I'm sure she'll be like, they forced me under duress. They sent me an email and they stared at me. I didn't really mean to do it. Probably. I don't know that to be true, but that sounds on brand for her. But so Greg does not object to Laura dismissing those claims of domestic violence. So that's really all that is. They also asked for it to be dismissed with prejudice, meaning she can't bring it back up again. So we'll see. We'll see.
Don't tell her what she can't do for another Lost.
I was going to say, we are just quoting the shit out of Lost today, aren't we? Buffy and I love Lost. We love it. We love it. Oh, yes. Thank you, Tex, for all of those places you can listen to the Love Trapped podcast. Basically, anywhere that there are podcasts. So, all right. You're a Lossie too, girl. Or I'm not sure, but we're nerds. I'm a huge TV nerd. Don't even get me started. I need a whole show just to talk about my TV. So anyway, so that's that document. She's saying, all right, fine. We won't talk about the domestic violence, the criminal part of it. All right. So now this one is interesting. Just because I've never seen this kind of document before, but it happens. It's not like I've never read one like this. So that's the only reason why. Who wrote it? Who wrote it, right? This is by Wood. I think it's submitted by Woodnick. Yeah. So this is basically them saying this was, I'm sorry, let me look at the date here, February 7th, 2022. So this is them reporting of an earlier meeting, right? Saying that they talked, and I don't know. I mean, both sides talk all the time in most cases, right? They're supposed to be friendly. Remember in the judge's orders, she was like, this could have been an email. And I expect you guys to be able to communicate like normal people do.
Well,
right.
You thought wrong.
And I think probably the reason I've never really seen one of these before is because it's normal. But I wonder if Woodnick filed this just as like proof that it happened. You know what I mean? Like, well, it was submitted to the court, so she couldn't like put a twist on it or something. I don't know. So, oh, look, there's our bestie, Laura Owens in chat. Hey, girl. Hey. All right.
I love Laura Owens.
I know you do. I know. So plaintiff Laura Owens and defendant Gregory Gillespie, by and through his counsel, notifies the court that they participated in an early meeting pursuant to Rule 16B on February 3rd, 2022. Now, during the early meeting, the parties discussed and stipulated that the case being designated as a Tier 2 case, as there is likely to be more than minimal documentary evidence, like voluminous email and text exchanges, in addition to medical records. So I think this was them also kind of being like, Laura, this is how this works. Okay. This is how a civil suit works. Okay. Now, they're also going to have more than a few witnesses. 6 witnesses were discussed at the early meeting, with additional witnesses discussed as possibility, including multiple medical providers and at least one out-of-state witness, and may include medical expert witnesses involving multiple theories of liability and counterclaims. So they're just letting the judge know, listen, we talked about shit with her. We did what you asked. We sent it to you as proof. And this is what kind of case we're possibly expecting it to be there. So, and that's really, I mean, the point of those is just so you can kind of get the background of like how things are going in the case at this moment.
So do we rate civil court like we do hurricanes or whatever? It's like Tier 2.
I guess I've never heard of
Category 2 hurricane.
Yeah, I've never heard of the tier system either, but probably
This is the Category 5.
It's gonna be
total shitstorm.
Right. Well, they're right. It is a total shitstorm. I don't know if that's a regular thing or not. Like I said, I've never really seen one of those kind of filings before.
Yeah,
but different states, like, I don't know. Different states are weird. So what do I know?
Like the Category 2.
Now, this next one also, it says 53 pages. Don't worry, but these first 3 are all the same exhibits we've read, which I was very annoyed about when I saw that. I was like, damn it, when are we going to get some new exhibits in here? And don't worry, there are lots. DEFCON rating. All right. Yes, for sure. Now, this one is a notice pursuant to ARS 12-1841. And here's why this one's important, because I like this. So defendant Greg Gillespie, through his counsel, is notifying the Arizona Attorney General, the Speaker of the House of Representatives, and the President of the Senate.
Do you have a new
paper? Sorry.
I was going to say, where are we reading this?
Thank you. I'm very bad at switching.
Share with the class, Llama.
I know, right? All right. So they're going to be notifying the Arizona Attorney General, the Arizona Speaker of the House, and the Arizona President of the Senate that Greg intends to raise a claim of unconstitutionality relating to the application of ARS 36, whatever. And in this, it's a copy of the pleadings, including the underlying complaints, all right, as well as the motion to dismiss. They're saying, basically, this should have been dismissed, and at this point, this is freaking unconstitutional, okay? And they give a very brief basis for the claim and descriptions of the proceeding, which is that the parties, as we know, had a brief relationship. We'll refresh the class. The parties had a brief relationship in June of 2021. In July, Laura allegedly, I love them so much, discovered she was pregnant and informed defendant of the same. In late July, Laura allegedly obtained abortion pills and took them while on the phone with, but outside the presence of Greg. After allegedly administering the second pill incorrectly, because somehow
they should have put it in like all caps and put it in bold, like she likes to do underline.
Right.
I mean, I'm all for subtle snark. They should have done that.
I do appreciate the snark we've seen so far. And guys, it gets so much snarkier, wouldn't it? It's so much snarkier. So after administering the second pill incorrectly, because pills are hard, Laura claims that she unilaterally obtained and took the pills again because apparently it didn't work. I don't know. But the medical abortion was unsuccessful because of her super.
How does she know it didn't work?
Well, because she just knows, obviously.
How?
Yeah. the baby sold her.
Oh,
something.
That's how that works. Okay.
Right? She also never went to a doctor.
But that's what I'm saying. Like, how do you know it didn't work? How do you know?
Exactly. He does have a hella sense of humor. You put your pills in your landing spot. She put it up her butt or something. It didn't work. I don't know.
I can't imagine why.
There has been talk of butt stuff, so maybe. Now, days later, Laura states that she received additional abortion pills. So this is the third time, taking the second pill in the presence of Greg on August 5th, 2021. During these events, Laura and Greg were communicating through text and phone calls, and Greg was supportive of Laura's actions. Now, on August 11th, 2021, Laura filed her complaint, which alleges Greg's communication with her during this time qualified as to intimidate or coerce in any way a person to obtain an abortion. While Greg denies the allegations levied by Laura, the motion to dismiss challenges the constitutionality of ARS because, in addition to being void for vagueness and overbroad because she sucks, it acts as an impermissible content-based prior restraint on speech in violation of the First Amendment of the United States. Furthermore, the statute violates the Due Process Clause of the 14th Amendment because it is impossible to determine what acts a person must not do to avoid liability. So basically what they're saying is and they include all the stuff they filed, the text messages we've already read and all that. It's should Greg, what he have said, been considered free speech? I mean, he didn't. We read those text messages.
Right.
It did not seem coercive to me. As a matter of fact, the person putting on all the ultimatums was Laura the whole time.
Right.
So, they plan on going to the whole state of Arizona about this.
Well, that makes sense. At what point are they not allowed to have their opinion on whether or not she should take it? And where's the line between I want you to do this, you need to do this, and you have to do this or else,
Right. Because normally the abortion coercion claim is a more medical personnel type of thing. It's not really like a normal person to person thing she's claiming.
I can see, because that could be a point of contention in a lot of relationships, and that makes
right. Yeah. Exactly. That could be very problematic for all different sorts of cases. So they're really trying to shut this down. Her abortion coercion claim. Because remember
where that went. Did it go anywhere? Was it
I don't know.
Up?
Maybe we'll find out. I don't know. I have not. Like I said, I am not as familiar with Greg's. I have not read ahead very much, so I can't tell you. I just have a long list of them. So that's really all there was to that. Now, because all the stuff we just read had been filed, boom, 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 right? Woodnick and them are let's go then, okay? I know how to be a lawyer because I am one. Laura, who's still representing herself. Let me share this tab instead. There we go. Let us know when you want spoilers. You can leave spoilers in the chat. That's totally fine.
I am the spoiler queen.
That's true. Buffy. I usually have a strict no, but no, you're totally fine, guys. You let us know. Now, whether
I usually give the spoilers, but I will read ahead to spoil a book. And this is why this is hard for me not to read ahead.
That's true. She's doing such a good job. Also, no, because sometimes I've noticed in the list, who was it in our comments or something, Buff? You said they left for the phone call for us. So I made sure to put that in our list. The phone call that Greg recorded of Laura.
Yeah.
We haven't listened to it, but we did put it on our list because I didn't have it on there to go along with the timeline of things. So everything you guys send us, even if we haven't talked about it now or watched it now, we are definitely taking that information and putting it in our little list as we go along. So you guys are so helpful, by the way, you veteran cult members, you. Well,
The
look at
OGs.
that. There's our Liz. Happy St. Patrick's Day to you, our friend from Ireland herself. Hello, Liz. Hope you're
And
having
not a one of
great
us
day.
are wearing green.
No, but I got the red hair, so I don't know what to tell you about it. I'm good enough. I don't have to wear green. Also, I have a green screen, so it doesn't. I'd be invisible today, which I guess maybe I should have.
You would just be a head, which would be funny.
All right. So, right. No, because B has one of those, green mask that goes all over your face.
Uh-huh.
And so I literally could make myself invisible if I wanted to.
That would creepy. That would be really creepy.
I know we are victimizing her by reading public court documents that she wanted sealed because it makes her look bad. Now, this one is a longer one. Now, this is the defense's motion to dismiss and the motion for judgment on pleadings on plaintiff's abortion coercion claim. So I think this is where they're going to explain more of why, like, this whole free speech, like, let's just get rid of this, right? Because the judge also said that the way that they responded to, what was it they responded to? And she was like, that's not the right place to ask for a dismissal. So I think this is their like formal, officially doing it. You remember her saying that?
I don't. Yeah, I do. I just don't remember. I mean, I remember that. I just, yeah, there's.
I don't remember which part it was, but it was one of the ones we read last week. So I'm going to read a page or, okay, this is broken down into sections. So, okay.
Read to me.
Read to me. Fine, Buff. Whatever you say, Buffy wears the pants in our relationship. All right. So it says, let me make this a little bigger for everybody. I keep forgetting to do that. There we go. So we can all read together. Now, defendant Greg, by and through his lawyers, hereby respectfully move to dismiss the allegation of abortion coercion contained in Laura's complaint pursuant to these rules and as a motion for judgment on the pleadings. So summary of judgment being like, can we just decide now? All right, let's just do this pursuant to Arizona rules of civil procedure. This court denied a prior motion to dismiss on December 14th, 2021 for a failure by Greg to consult with Laura pursuant to Rule 12 and to allege Laura's complaint did not contain facts warning relief under any interpretation. This current motion differs significantly, which is not slightly at all, from the previous, as it is confined to a particular statute cited to by Laura in her complaint and contains allegations that the court must adjudicate pursuant to this code. Attached to this motion is a good faith consultation certificate as required by Rules 7, 1, and 12. As and for his motion, Mr. Gillespie states and alleges as following. So this is them doing what the judge asked them to properly do for their issues to be considered. So I think they're going to be taking her to lawyer school in this, basically, because she wanted to quote something and they're like, okay, well.
At the end, do you get a good faith consultation certificate? I'm just kidding.
Suing that your daughter's school is? Well, I don't know anything about Irish law, but I will happily look into it. If you're like, I'm not a lawyer, but that's crazy. I'll tell you what, school's tough now these days.
Don't
anyway,
get it. That wouldn't happen here. Schools have like immunity or something.
Right? Okay. Right. This claim is crazy. Like, did he force her at gunpoint? And remember, here's the thing is I don't see how she can claim abortion coercion when she was literally like, if I abort it, you have to date me. Like, right. That throws it all out right there because you were willing to terminate to go on a freaking date. Even while you had still filed these you had taken him for a civil court. You were reaching out to his lawyers and being like, well, if he still wants to date me, I'm willing to drop everything with prejudice. Like, how? There's no coercion there, in my eyes. But let's see what the defense takes her to law school about.
Date me and get sued.
Right? Such a great foundation for a relationship.
Is that coercion? That sounds like coercion.
That sounds so much like coercion, extortion. Interesting. All right. So Laura alleges 3 counts for relief in her complaint, which she voluntarily dismissed upon learning that Title 13, the domestic violence, does not create civil causes of action. Because she didn't know that, and a lawyer had to tell her that. But don't worry, she's basically a lawyer. 2, the code, abortion conducted without informed consent, and 3, the tort of intentional infliction of emotional distress. So plaintiff's claim for relief under this ARS code fails because the statute does not create a cause of action for any of Greg's conduct alleged in the complaint. Moreover, to the extent that the statute creates a cause of action, such action may only be brought against a person who conducts an abortion without informed consent, which the statute defines precisely and at great length in a manner unrelated to any of the defendant's alleged conduct. No such person is joined in this action, nor does Laura allege that any person other than herself performed or induced an abortion as defined in the statute. And that's why it's usually a medical claim of some sort.
Okay, that makes sense.
Right. So he didn't do anything actually to cause the abortion. He didn't shove the pills down her throat. He didn't grind them up and put them in her drink or, say, if you don't drink this right now, nothing causing that to him.
Smarter if he did.
Even though I think, doesn't she claim at one point, she claimed that he did put her fingers in her mouth to make sure she swallowed the pill, which is, again, I don't think that really counts.
Is that cool? I mean,
and I don't think that's true.
Already swallowed, though.
Right.
But she put, I don't know. It's like she.
You guys are so funny in chat.
Her logic is just.
It's something. All right. So plaintiff's complaint fails to state a claim for which relief can be granted. The abortion coercion claim. Now, here's the statutory language. It's going to get very legally, but we'll do our best to interpret it. We're not lawyers. Remember that. We could be wrong. Now, but we're just as qualified as Laura Owens. Actually, probably more so.
Usually wrong.
Now, Laura alleges that Greg has violated the ARS code. This subsection states in its first sentence, a person shall not intimidate or coerce in any way any person to obtain an abortion. Okay. Now, this provision does not contain any further explanation of what intimidate or coerce in any way means in this context, nor does it state that a person who does these things is liable for damages. So
it's overly broad.
It's very broad, and it doesn't say that you should be able to sue somebody over it. So, hi, Amos. Hi. They were Tic Tacs. Now, it also does not on its face create a cause of action for damages against Greg. The remainder of subsection G goes on to state that a parent cannot coerce a minor to obtain an abortion, then prescribes certain remedies for a minor whose parents deny her financial support due to the minor's refusal to have an abortion performed. See how that's starting to make a little, a real life scenario of actual coercion, because it's a minor. They can't provide for themselves.
I didn't even know that was a thing.
Well, I didn't either, but apparently it is, and I wouldn't be surprised if it is. Now, that is intimidation and coercion, because if you can't pay for your stuff to literally survive, and they're minors, then that's a problem. Again, nothing in subsection G or the statute defines intimidation or coercion, nor does any part of the statute expressly state a cause of action for intimidation or coercion. In matters of statutory interpretation, the court must read the entire statute and interpret each term within the context of its accompanying provisions, which is that way for all statutes. If you've ever read them, it'll be like, item 1, and then A1, B1, and it'll usually be like and or, right? It has to include like different levels to actually meet the statute. And for good reason, right? Because every situation is different. So look at that text packet. They are currently revising that statute. Well, that's interesting. Oh, there's my coffee. It disappeared in front of my microphone. I'm going to have to read up on that more. Now, in 36-2153, there are several such lists. The statute lists information that a physician who is to perform an abortion must provide to the woman receiving the abortion orally and in person at least 24 hours before the procedure. The statute, you'll email it to me? Yeah, that would be great. Thank you. You've emailed me before, so I think you have it. If not, one of the mods can put my email in the chat for you guys. The statute lists additional information that must be given orally and at least 24 hours before the procedure by the physician or a qualified professional to whom the responsibility has been delegated. We don't know where she got these abortion pills, even if she even actually got real ones. We don't know.
At the gas station. It was at the gas station. It was at the checkout counter.
It's not Tarte.
Little clear boxes.
It's not Tarte. We can change my email to Tarte, though.
I think we've got you a new name. You are Tarte.
Tarte.
Oh, come on. You've never misspelled your name as Tarte.
Not Tarte. No. I love it, though. All right. So the statute then lists other requirements for receiving and documenting the patient's informed consent, including information about the drug, mifepristone, and the medical indications supporting an emergency procedure, if applicable. If you notice, these are all medical things that medical people have to do, because that's usually the process of making this happen, Laura. Then the statute instructs the statute. Then the statute instructs the Department of Health Services to establish and maintain a website with an enumerated list of information to be kept and made available. So basically, you just have to be like super informed by law. Later, the statute identifies people who may file a civil action under the statute and the available relief for damages resulting from a violation of the statute. Again, expressly stating that the claim is based on failure to obtain informed consent before performing an abortion. Okay, so that's what the statute is actually about so far. Oh, wow, it goes all the way down to L, 1 through 3. Oh, man, that is a wordy statute. But she probably read it and she was like, I'll take it. Thanks.
No, she was like, this is it. Abortion coercion. I'm going
found
with
it. Right. Now, the statute does not create a cause of action against the person who did not perform an abortion without informed consent, i.e., if you believe Laura, Greg. All right. Because he didn't give her all the information when he told her to take these pills that she got, apparently.
Sign here.
Right. Now, ARS does create a cause of action under subsection K, specifically for a woman, the father, of the unborn child or a maternal grandparent to recover against a physician who performed an abortion without informed consent as defined by subsection A detailed above. Okay, so the woman, the father of the unborn child, or the maternal grandparent could sue a physician. Okay, so in addition, this is what the subsection K says. In addition to other remedies available under the common or statutory law of this state, any of the following may file a civil action to obtain appropriate relief for a violation of this section. A woman on whom an abortion has been performed without her informed consent as required by the section. So again, Laura, how did you read this? You're so smart. You're so smart, Laura. How did you read this and think that this applied to you? Because if you went and got the pills, you're pretty informed, right? Right? So.
Well, she had to have been informed by the doctor who gave it to her.
If she even got, I don't think they were even real pills, obviously. That's what I think.
Can she prove it?
Right?
I'm guessing no.
No. Now, two other statutes in Title 36, Chapter 20, impose other requirements relating to informed consent, all of which are acts and conditions required of the provider. In fact, every statute in the chapter describes requirements for medical providers, not private citizens. So, okay. Now, silly Buffy. I know.
I don't know why I asked dumb questions.
Now, the plain language of the statute limits the cause of action to the conduct the statute requires of medical providers conducting abortion procedures, which Greg is not. The only express claims it creates are for the woman, the father, or maternal grandparent to sue the provider who performed an abortion without informed consent. Every cognizable claim under the operative sections of the statute require that an abortion was conducted without informed consent, and the duty to obtain and keep record of informed consent rests squarely on the physician, which Greg is not. The statute cannot be reasonably read in any way except that relief must be sought from the physician who performed the abortion. The law says you can only sue the medical people. Because the cause of action arises from an abortion conducted without informed consent, and the statute's definition of informed consent refers entirely to the acts a provider must undertake, there is simply no cause against a private citizen unless they performed an abortion procedure, an act that is prohibited by law. So it's illegal for them to do that in the first place. So if they did it, there would be probably criminal charges. All right. It wouldn't just be civil at that point. So, oh my goodness. I'll tell you what, I got this new Kramer, the Harry Potter butter beer. I mean, it's good, but I'm not going to get it again.
It's not great. I would say the llama saying, it's not great.
It's not great. It's not bad, but.
How committed are you?
I am not that committed to buy it again. Feed just happened to get it for 99 cents. Just one bottle. Because the other ones he got me.
Well, also, it says Harry Potter on it. So it's just like a given.
Yeah. Yeah, it's not great. It's not. I'm not
I don't like creamer in my coffee at all.
I know. You're whipped cream girl.
I put whipped cream in my coffee.
Well, Liz, you got a lot of people that are interested in you and your story. So you need support. You can find all the mamas because we are very supportive mamas as well. And you'd be surprised what we've all been through with our kids. So you never know. Hopefully you won't feel so alone because being a parent, it can be very lonely. Very lonely. So you have us to talk to all you want. All right, so he can't even perform one because it would be super illegal. Now, the remedy, if there is one, cannot come from Greg because he did not perform or induce an abortion without informed consent. He cannot do so, nor does the complaint allege that he did. So, really nailed it, Laura. Nailed it. Moreover, he has no duty to engage in any of the acts required by the statute or in any other statute in Title 36, Chapter 20. The complaint asserts that Laura obtained abortion pills, administered the first pill, not in Greg's presence, so how can that be coercion? Administered the second pill a day later, outside of Greg's presence, again, allegedly. Administered the second pill again 2 days after that, because I don't understand all these pills, but okay. Outside of Greg's presence, administered the first pill again 4 days after that outside of Greg's presence, and finally administered the second pill for a third time, the only relevant act in Greg's presence, another day after that. How many pills is
all
that?
of that is so questionable,
right? Like, I need to look up to see if it even does anything if you're pregnant, but still, that seems like if you were taking, like, that does not seem like a woman would be doing well, quite frankly, with how those pills work, like what they do, you know, to have that happen. Like, you had the pain. I could not, there's no way I could get this.
There's 2 pills, right?
Right.
She took the first one.
Mm-hmm.
And then she administered the second pill a day later.
I guess. I don't know the timing on them. Her time, yes, but I mean the actual one.
The second pill again 2 days after that, outside the defendant's presence. Okay. How many pills did they give you?
2, as far as I'm aware.
Okay,
but
so
I don't.
where did she get another set?
And then another set. I don't know.
But it doesn't even say she took. It says it took the second pill again.
Yes.
So she got 1 set. She took 1 and 2.
Mm-hmm.
Then she got another set and just skipped 1 and went straight to 2.
Yes. Then
she went back to 1.
Yeah. And then took the second pill in front of Greg.
With another. So you mean to tell me we got 3 sets of pills if they come in packs of 2?
Mm-hmm. I think.
So she had to go to the abortion clinic 3 times because I don't think they give you backup.
No, I don't believe so.
So she went 3 times to get these pills.
Mm-hmm.
1, 2, 2, 1, 2. That's the order.
Yeah. Just
I
it
feel
makes
like
no sense.
If a doctor gave you the first one, you came back and said, yeah, it didn't work. Can I have another set? That they would be like, I'm sorry. No, I don't think you get to do that. That's not plan B though, right? That's different. Right. Plan B is the morning after pill, not an abortion pill.
Yeah, they're very different. Very, very different things. Mm-hmm. With way different consequences. Like plan B, nothing's gonna happen to you, really.
Well,
the abortion
that's
one, it will.
Yeah, that's why I was like, it's not plan B. That's one you can get.
You're right, Dan Montana. She did say that she got them in unconventional methods because
she bought them off the street. Is there a dealer selling abortion pills on the clinic? I mean, on the corner? I mean, I'm just curious.
Right, because she's this is in California, yeah? I think Greg.
How many drug dealers does she know?
Or no. This is in Arizona at this point. That's right. Only Mike was in California. So Greg and I think Clayton are Arizona. Yes, Chad? I think so.
Okay.
Yes.
So at one point,
yes, because they keep referring to Arizona code.
Okay. She went back to California to get them, but she didn't get them from the same clinic. So she just clinic hopped.
Mm-hmm. I guess so. Again, I don't think she even knows how any of this shit works because it doesn't make any sense.
I don't think it. I mean, I would like to think, and I don't know anything about it, that there's a network that like tracks all this? I mean, I don't know. It just
Who knows?
seems
I didn't
very
even know
strange.
you could get HCG. So who knows? But she doesn't
Well,
know how
I
to
mean,
work.
it's not like she's ordering it off of a website. Now, if she did do that, that's weird.
Right.
But, okay.
Now, none of the conduct alleged against Greg constitutes performing or inducing an abortion, nor does the complaint allege Greg had a duty or failed to comply with the statute's informed consent requirements. So they're basically being like, bitch, you dumb. Okay. It doesn't even apply here. Okay. Now, therefore, even accepting all material facts pled by plaintiff are true. There's your underline, Buffy. Sorry, you probably can't see it. Boom, there you go, babe.
But it is not in bold. It is not all caps.
Right, but that's them being like, even if all of our lies are true, we see you. For purposes of adjudicating the pleadings, she, quote, would not be entitled to relief under any interpretation of the facts susceptible of proof. This is because the statute simply does not contemplate the relief she is requesting. So they're saying, listen, if all of your claims even are true, you can't sue and get any money out of it because that's not how that works. Excuse me. Oh, look, here we got some information about that. The first medication, mifepristone, is typically taken first to block progesterone. Okay. The second medication, misoprostol, is taken within a specific time frame, often 24 to 48 hours later to empty the uterus, which is painful and a mess. Okay.
But that one didn't work. Her uterus was not emptied.
That's right. She has a steel uterus. That's the painful part. The first part, not so much. The second part is going to be the part where you notice. And it's not, again, it's not going to just like, oh, it's been an hour, it's done. This is going to take several days to kind of clear itself up, if you will.
So I guess she was like, oh, my uterus didn't empty. It must not have worked.
I'm going to go with that. Well, I'm not covered in blood everywhere, which I don't even think she realizes happens. It didn't work because I got a steel trap uterus with my genius superhero babies in here. So.
Boot scoot funny. I think she's making fun of us, man.
Now,
trying to apply logic where there is none.
I know. It's hard. It's so hard. Oh, we have a follow-up care appointment or test is necessary to confirm the procedure is complete and to monitor for complications. And we know damn well she didn't do that ever. No, because the complications, if there are any, are fucking serious as shit. Like, you will die. So, if any, dead biological materials in there, it's going to cause some serious health problems. So yeah, she's just a liar who lies about all of the things. All right. Now, assuming, here we're at the intimidation or coercion part, assuming arguendo, which I've never heard of that word, but I love it, that the statute creates an independent cause of action in the absence of a defendant performing an abortion without informed consent, the only remotely cognizable claim is that a person's intimidation or coercion forced someone to perform or induce an abortion. As discussed in the previous section, Laura undertook all of the affirmative acts that she alleges resulted in the termination of her pregnancy and did so almost entirely out of Greg's presence. He didn't show up with the pills. He didn't put them down her throat, crush them up, do any of that. She didn't have them around. Her complaint does not state that Greg coerced her, but rather that she terminated the pregnancy, quote, for the sake of a relationship with Greg. Because that's exactly what she claimed happened, which is crazy to say out loud to anybody. Therefore, taking the facts alleged in the complaint as true, Laura herself asserts that she chose to terminate the pregnancy based on the belief that she could continue to have a relationship with Greg. In the light most favorable to her, it could be surmised that Laura means to claim that she relied on promises from Greg. Accordingly, the question is whether promises qualify as intimidation or coercion in this context. Does it? Does promises? Because promises are so scary. Oh, jeez.
Is it coercion usually threats?
Yeah, right. And I would think threats, you wouldn't probably want to be begging somebody to be in a relationship with you.
Well, I don't recall him begging to be.
Right. Oh, you don't have to take the second one? That's interesting.
Well, that would be interesting.
I'm going to go down a rabbit hole, I'm sure.
Blocking progesterone be enough?
I don't think so, to be quite honest. But I guess you can. I don't know. And then they say over 80% of folks that need a DNC after taking the medication. I do believe that. A lot of women have to have DNCs, to be quite honest. So doing everything naturally, whether it's miscarriage or abortion, it's not as high as one would think. That's why it's so important that women are able to go to the hospital and report having a miscarriage and getting the proper treatment for it, because it naturally occurring from point A to point B, meaning it just your body passes it as it should. There's a lot of complications where that doesn't actually happen, to no fault of any woman's. That's just how things are. Luckily mine was able to just naturally, but the first thing they tell you is because they'll check exactly where. Maybe this is more graphic, more than what people need to know, but I don't really care. Laura doesn't know how this works, so maybe she's watching and she can understand the female anatomy. But they'll see where the baby, the fetus is in. So like if it's high up in the uterus, if it's still in the uterus and not on its way down to the cervix, like giving birth, right? It's exactly like that. That's what's happening to your body, basically. You have a good chance of then passing it naturally. I mean, it's going to take a couple days. I think mine took about 48 hours for the sac to actually come out. But if it's high up and doesn't make its way to the cervix, that's when you need a DNC, because it is very, very dangerous. You can and most likely will get sepsis and die. But they track all of that for you when they realize that you're having a miscarriage. So because it is that serious. And then because I was able to pass it naturally, you still have to go get checked up in a month to make sure that everything that needed to come out did come out. So that's why I'm just like, you are so full of shit, girl. Like, it is very,
that is not
very
how this
serious.
works.
Yeah, no. But I can see also if you have to take that, because listen, you can have a miscarriage too, if it doesn't come out, they will give you abortion pills. And you're not having an abortion because the fetus has already passed. But to get that movement going, like that was an option too. And I was like, well, I had friends that have taken it, and it's fucking horrible to witness. Like, their screams are awful.
Well, you're inducing contractions. That's
exactly.
Thing.
Yes, it's the same thing as birth, basically. So she's just so full of shit. But again, that's why you get checkups on these things, because I don't know what woman wouldn't. I mean, there's maybe situations where, let's say, you can't. All right, insurance, who knows? But if you've already started this process,
But let's face it, that's not her issue. She has great insurance. Did you see she paid $10 to see it?
Yeah, that's true, right? Right. So, yeah. Now, anyway, back to this. All right. So therefore, taking the facts alleged in the complaint as true, Laura herself asserts that she chose to terminate the pregnancy based on the belief. Oh, wait, we already read that. I'm sorry. So now we're at our promises considered intimidation and coercion. Okay. So Title 36 does not define intimidation or coercion, but the terms are used in other statutes with specific meanings. So this ARS statute, a criminal statute, defines intimidation as intimidating by words or conduct to, injure someone or cause serious damage to their property. To cause serious public inconveniences, such as evacuation of a building, or to injure or damage the property of another person, to assist in a criminal street gang, syndicate, or racketeering enterprise. So it turns out intimidating is what we all think it is, except for Laura, who also doesn't know. Exactly, half-ass fashion. Exactly. Like, she's so like, oh my gosh. This woman. Okay. So, ARS code, the criminal sex trafficking statute, defines coercion as threatening to abuse the law, making a passport or other government identification inaccessible to its owner, extortion, causing or threatening financial harm, or facilitating or controlling a person's access to a controlled substance. The complaint does not allege that Greg did any of these things. Now, also, yes, there have been women in domestic violence situations that I am sure have been absolutely intimidated and coerced, because they probably live with that person. They're probably financially dependent on that person. But none of these things apply to you, Laura, at all.
No.
Yeah,
I don't understand. She was like not even living with him. She can like literally just do what she wants.
Yeah. Now, Greg cannot find any legal support for Laura's position that offering to remain in a relationship with someone if they terminate their pregnancy is intimidating or coercive. The act she alleges that Greg promised he would work towards a marriage and eventually have a child with her after, 4 dates? Attend an event with her, the wedding, wanted to start a family with her, wanted to meet her father, support her after this, and begin their relationship, are not even remotely of the kind of words or conduct that Arizona law elsewhere defines as intimidation or coercion. The only acts in the complaint that might come close are the alleged threats to, quote, go public with Laura's abortion to damage her reputation, as if she even has one. But that is alleged to have occurred after Laura's actions to abort the pregnancy and is therefore temporarily excluded. Again, assuming all the facts alleged in the complaint are true, there is no conceivable claim for which relief can be granted. So, all right, why don't you read this part? I need to rest my little voice.
Okay. Plaintiff failed to join a necessary party to recover for an abortion without informed consent. Because Laura's claim can only be remedied through a cause of action against the physician who performed the abortion without her informed consent, or is at least predicated on the requirement that an abortion without informed consent actually happened, Laura has failed to join a necessary party.
That's right. The only person that did it, boo face, is you. So, okay.
Boo face.
A boo face. Amy's going to be like, that's what you call me. How dare you? Give her that name. Probably.
So, ARS... I'm not going to read all that. Imposes an affirmative duty on the physician performing the abortion to obtain the qualifying individual's informed consent. Under Rule 19A1A, the physician who performed the abortion on Laura must be joined because the court cannot accord complete relief, or any relief for that matter, among the existing parties.
Yep. So they're saying, Laura, you haven't even brought a doctor in this situation that actually goes with the statute. So you get nothing, as Willy Wonka said. Nothing.
For that, you get nothing. You lose. Good day, sir.
Exactly.
Sorry.
That
was a childhood memory.
I love you, Buffy, in your quotes. I love it. All right. So now we're here.
I love that we can make these quotes and we know exactly where we are. I appreciate that.
You with the
when you find your people, guys. When you find your people.
Right. Never let them go.
Okay, so even if Greg's actions did create an actionable claim for an abortion without informed consent, the complaint must necessarily be against both Greg and whoever performed or induced the abortion.
Which would be you, Laura.
That would be you. The provider who conducted the procedure or, as here, authorized Laura's use of an abortion-inducing medication has the duty to receive and document informed consent. If Laura acquired the medications, which she administered 6 times without consulting without consulting a medical provider, then there is no intervening party who could have received informed consent. Paradoxically, the only person who could have ensured informed consent would then have been Laura herself, because that would clearly not be a cognizable claim. The complaint would have to be dismissed outright.
It's crazy to me that this case continues after this, but okay. I don't know. I'm not a lawyer.
Yeah.
So. But I do appreciate them serving her throughout all of this. Like, it's you.
It's like you were but also the doctor that supposedly gave it to her, but she's not going to produce any proof of where she got it from. Oh my God. That was amazing.
Oh my gosh. I don't think they were real abortion pills. There's no way. There's no way they were. But, why would Greg know any better? You know what I mean? Like, or she could have created fake packaging for me either. So, yeah, she did say that she took the pills wrong because taking 2 pills is very difficult for Laura. Counting is hard.
Well, she did them wrong because she did them out of order. Yeah,
she had baby brain, Buffy.
Oh, she has something.
Jeez,
that's not what I was gonna call her brain, but she has a baby's brain. Yes,
that is true.
Not a baby brain.
That is true.
Oh, she's baby brained. Big brained, baby brain. Okay, stop it. I'll go home. Okay. Right, now I gotta figure out our map.
I know. We should dismiss
it. In the alternative, I found it. In the alternative, if Laura did receive authorization from a physician and now alleges the abortion was performed or induced without her informed consent, then relief can only be afforded if that physician is joined as a party. After all, their intervening breach of duty proximately caused the alleged harm. Right. The physician, if there is one. High five, Greg. High five.
I know, right?
Okay. If there is one, must be at least partially liable under the statute and share in the attribution of faults and indemnify Greg. Laura has failed to join the physician as a necessary party to the litigation, making it impossible for this court to adjudicate the ARS claim.
So, where's the doctor, Laura? You're a lawyer now. What's so funny in Hannah Montana about the Oompa Loompa song? The other day, little Llama was practicing his violin, and that's one of the songs they're learning to play. And I was like, is that the song I think it is? And then it was stuck in my head all night, and I was like, mother.
Did you walk around? I was going, Oompa, Loompa, Loompa. Yes. You know what? Laura needs an Oompa Loompa song.
Yes. He was doing that song and Stairway to Heaven. It was a very weird music choices.
It was a very weird day.
Yeah, it was.
I feel like I'm in a fever dream, but I can picture after every single one of these motions, like oompa doompa doopa dee doo.
We need to come up with a song.
Lesson for you.
Oh, she's very much like Violet. I'm just saying.
No, it's Veruca.
No. You're right. I'm sorry. Wrong one. I just had
Don't
Blueberry.
care how I want it now.
Mm-hmm. Maybe she needs to watch what happens. Anyway, all right, back to this.
She was a bad egg.
She was a bad egg. All right, so here this statute is unconstitutional. The statute here cited in support of Laura's complaint is unconstitutional as applied to Greg. If the statute creates the cause of action Laura alleges, then it acts as an impermissible content-based prior restraint on speech in violation of the First Amendment to the United States Constitution. Because they're like, oh, okay, so if Greg is responsible, he's just not allowed to say things? He has a right to say he doesn't want you to have the baby. He has a right to tell you that you should take them. So that's,
He said a lot of questionable things, but he has a right to say them.
Laura Owens, you are so bad.
So cute. Was that your nickname? You are the little Oompa Loompa. I can see that.
Don't forget he has cancer too. All right. And a long list of health problems that she needs to tell everybody. But also, in case you didn't know, he was a famous host of a radio station in San Francisco. He is a local celebrity there. Sorry. I wanted to make sure he gets his due.
I'm going to get a shirt that says, "Do you know who I am?" And just see how many people are like, "Who are you?"
Right. All right. So they're like, furthermore, the statute violates the due process clause of the 14th Amendment because it is impossible to determine what acts a person must not do to avoid liability. So then they go and say, we're going to break this down for you, Laura Pans. We're going to break it down so you understand. This is also what they submitted in that one I just read to you before this, where they said they were taking this to this Attorney General, the House of Representatives. This is one of the things they attached
one
to
of those
it.
Supreme Court cases.
Mm-hmm. So the First Amendment guarantees citizens the right to freedom of speech, and through the 14th Amendment, this right is protected against state action. Okay, remember that. Anybody can say whatever they want. I can say whatever I want to you, Buffy, and there's nothing you can do about it. You can be mad at me, but there's one thing the government can't do, and that's tell me what I can and can't say sometimes, most of the time. So
I'm going to send you a cease and desist.
Right, because one of my favorite, it's like, I can say what I want to you because it's my constitutional right. And I'm like, okay, but I'm not the fucking government, so I don't know what. Okay, weird flag.
Cease and desist. Stop talking about me.
Now, a statute, and by the way, I think this is an excellent point that they brought up. Again, not just for Greg's case, but in general, right? Because if this in any way set any precedents, there could be a lot of negative things that come out of this. You know what I mean? So, a statute acts as a prior restraint on freedom of speech when it suppresses the precise freedom which the First Amendment sought to protect against abridgment. The Supreme Court of the United States has held there is a heavy presumption against the constitutionality of prior restraints on expression. Reasonable restrictions on time, place, or manner of protected speech are not prior restraints. Here, the Arizona Code seeks to prevent individuals from expressing their opinion or belief about abortion with no regard to time, place, or manner. The relevant sentence of this statute, which prohibits a person from certain speech at any time and in front of any person, acts as a prior restraint on speech that the Constitution would otherwise protect. Discussing abortion law in front of a pregnant woman could be construed to be prohibited under the statute. Oh, wait a second. Wait a second here. They're saying that there is a code where you can't say shit in Arizona about this? Is that what they're saying? Interesting. I'm gonna open this up real quick. Let's take a, just so I know what I'm not talking out my ass here, because I apparently was very confused about what this chapter was.
Talking out my ass.
Oh no, it's still the same abortion coercion informed consent. That's what they are. Okay. Okay. We are on the right track, I do believe. Okay. So, because basically they're saying, oh, if he's just, discussing abortion with Laura, is that against the law because he was talking about it or whatever? Yeah, that's what I'm getting here. Okay. So discussing abortion procedures or the risk of full-term pregnancy at a medical symposium could be prohibited. Expressing one's personal opinion about the morality of abortion in a private conversation. Example, I believe that bearing an unwanted child who the parents cannot support is unethical, could be construed to violate the statute. All that would be required is that the speech intimidates or coerces a person in any way to receive an abortion. Because those terms are so impenetrably broad, discussed further below, the only guaranteed way to avoid potential liability is to remain silent. This is the textbook definition of prior restraint and plainly violates the Constitution, meaning like, so what? You're not allowed to say it. We can't just make it so people aren't allowed to say anything at all, if that's where they want to go here. A person's right to express their views without fear of liability is precisely the freedom the First Amendment is designed to protect. The Supreme Court held this right can only be restricted in a few limited circumstances, such as when the words themselves are inherently likely to provoke a violent reaction. That's true. There are some limits on things you can and cannot say. Now, two individual parties privately discussing how to proceed with a pregnancy cannot be prohibited in the manner the statute purports. All right, so. Laura Owens. Cease and desist were going to be the names of my 100% twins.
I wish I had your wit and humor.
I know, right? That's fucking hilarious. You win an award today. Cease and desist. Too bad the real Laura is not that clever. Obviously, we can tell. A statute is void for vagueness under the First and Fifth Amendments when the person of ordinary intelligence is not given a reasonable opportunity to know what is prohibited, and where application of the law will lead to arbitrary and discriminatory enforcement. All right. So if somebody doesn't really know, like some things, right, like going in and shouting a fire when there's no fire, is everybody knows that, okay? You're just ordinary intelligence. You know that that's a bad idea. That is problematic, all right? But if you're, like, talking about how abortion in any way, like, I think it's immoral or unethical or you should get rid of it, why would you think that saying that is prohibited? Because it shouldn't be, right? So here, the statute states a person shall not, oh, here we got all in bold and italicized. A person shall not...
The caps.
No, shall not intimidate or coerce in any way any person to obtain an abortion. Also, I think they pulled those back a little bit because they were sending it to like real, the attorney general and whatnot. Oh. Now, the statute does not specify what it means to intimidate or coerce or what conduct constitutes any way of so doing. Although the statute's
big word,
ostensible purpose is noble. No one should ever be intimidated or coerced into any significant acts against their wishes. Its mandate is impossible to elucidate. Agree. I mean, I don't think anybody should be intimidated, of course, into anything. But, we need to define exactly what that means. So Greg's counsel does not routinely ask rhetorical questions and motions, but they seem warranted here. I like this. Okay. Does expressing a viewpoint about abortion, like Greg did, right? He's like, no, without knowledge of being overheard as any way of intimidating or coercing any person. Doesn't matter whether the person speaking has reason to know any person might find their opinion or actions intimidating or coercive. Would handling out pamphlets with information about the possible harm of teen pregnancy constitute intimidation? Does any person include someone who is not yet pregnant, or who the speaker does not know is pregnant, or someone who cannot become pregnant at all? Does an actual completed abortion procedure need to take place, or is the mere intimidating or coercive influence sufficiently actionable? And those are all very good questions, because that's taking a bunch of different possibilities. Right. But they're taking all these different kind of possibility scenarios and says, well, if all of what she's saying, this does constitute as, coercion and intimidation, well, where's the line? Does someone have to be actively pregnant for them to feel like they've been intimidated and coerced into not getting pregnant or being pregnant or anything like that? Like, where are we going? And this is usually how like a lot of laws are kind of decided on, right? Because you got to think of the overall consequences, because sometimes laws can do more harm than good. It would be great for one specific area, but it's so much harmful in the greatest sense that it really isn't justice in any way, shape, or form. So good questions. I don't have answers for, but good questions. Now, what if the intimidation or coercion pertains to a medically necessary procedure? All right, let's say Laura did need the DNC. All right, she needed it because she was going to die because the pills didn't quite work or whatever. All right. Or such as a husband pleading with his wife to terminate a pregnancy that will likely kill her if she carried to full term. All right. I mean, that's a pretty serious situation that sadly does happen. Childbirth is very dangerous. An emotional plea between individuals in their private sphere surely cannot be what the statute hopes to enjoin. Can a person intimidate or coerce themselves to obtain an abortion? Right? The statute certainly suggests it is possible with its amazingly broad sweep. It doesn't say a person shall not intimidate any other person. These questions do not have answers, and this is exactly why the statute must fail. If there is no way for a person to discern what speech or conduct is permitted, then the statute is unconstitutionally vague. A statute like this that has interpretations with no discernible standard of conduct is void for vagueness under the First Amendment. Now, chat, is this why one of you, I forget who it was, I apologize, said that they're looking over this law again is because of the argument that they have made here? Or is it for a whole different, like, was that your spoiler of where this goes? Just wondering, because now I'm putting together some of the comments and I'm wondering. So the legislative history is similarly ambiguous. Under a section entitled Miscellaneous, the statute sponsor states the statute, quote, stipulates that a person, including a parent or guardian of a minor, shall not coerce in any way a person to obtain an abortion. The legislative sessions following the statute's proposal are devoid of any discussion over the meaning of that provision, and the wording of subsection G remains the same in every iteration of the bill. The term abortion coercion has never been used by Arizona courts to Greg's knowledge, nor in the Ninth Circuit or the Supreme Court of the United States. Absent an ability to discern the meaning of the statute, individuals are not given a reasonable opportunity to conform their conduct to abide by the statute, and its enforcement is likely to be arbitrary and discriminatory. The ARS code contravenes the rights of individuals to exercise their right to free speech without restrictions or any semblance of clarity as to what conduct the statute is seeking to deter. And the code is void for vagueness and unconstitutional. So that's pretty interesting. Pretty interesting there. Okay, sorry. And I just spilled some coffee on myself.
That was me this morning.
I know, right?
My ADD had me everywhere. I messed up everything.
Okay, so wait, did I miss a? Okay, yeah. So here we are is overbroad under the First Amendment. A statute is overbroad when a substantial number of its applicants are unconstitutional, judged in relation to the statute's plainly legitimate sweep. So this part has nothing to do with anything Laura brought up. This is them making the argument that, like, well, if we're going to move forward with this is where all of these problems are going to come from. And so we're going to bring it to the attention of everywhere else. Because, again, if Greg is just saying, no, get rid of it in his privacy, then is that what we're going with? That if anybody says, I don't think you should have a baby, boom, intimidating
Basically,
or coercion?
It's what it sounds like.
Now, ARS, the code, does not provide any clarity as to what conduct would constitute a violation, nor does the statute define what constitutes as intimidate or coerce. Therefore, it must be presumed that the statute applies to any speech related to abortion if the receiver subjectively believes it to be intimidating or coercive, meaning you can say, hey, I think you should have an abortion would be equivalent to you either have the abortion or I'm going to fucking kill you. Those would be the same things
that
under the law.
Quickly.
You know what I mean? Well, I think that's what they're pointing out is that just voicing your opinion that somebody shouldn't have it by this because nobody wants you to define it.
Intimidation.
Yeah. You know? So, under this reading, anytime a person references, speaks about, acknowledges, etc., abortion, the statute may be triggered. It may be assumed for the sake of the analysis that the plainly legitimate sweep of the statute would be physical or violent coercion to obtain an abortion, terminate your pregnancy or else. But the broad language surely encapsulates speech or behavior that is not criminal, which is very important. Oh, look, here comes a text with some more information about those pills. If you are given both medications, you can take them together, says Planned Parenthood's info. If it is a suppository, oh shit, they do. I thought that I just made that as a joke. Why would you? If you suppository, you can take it 0 to 48 hours after taking the first pill. Nurse Buffy.
You know, it's a faster way of absorbing into the body than going through the gut.
Yeah, but like, is it necessary though? I mean,
people do it all the time. If you wanted to get your bloodstream faster, you put it in the mucosa, which also happens to be in your lady parts or your, so it absorbs a lot quicker. Once it goes to the gut, it's broken down, but it has to go through the digestive tract, which takes a longer time and can actually take your symptoms or take the effect of the drug can be diminished through the stomach.
Oh,
that's why you take some drugs IV.
Right. Well, look at that. We're learning. I didn't even know that putting it up your butt was an option. That was just a joke.
Those would be the mucosa. Those are your easily absorbed. Yeah, you always come in when we're talking about, or you're just sitting there waiting for a time to pop in. I do not believe you just popped in. You just wanted to wait till we were talking about girly parts.
Wow. That's interesting. Look at us learning all. It's like Llama learns about and Laura all at the same time. See, some people decide to do their own research, unlike somebody who files a bunch of stuff and doesn't know how shit works. You, Laura. You. All right. So as such, there are a wide range of conversations that would be considered violative of the statute that are protected by the First Amendment. In particular, the statute could prohibit communication that occurs within the zone of privacy protected by the 14th Amendment. The Supreme Court held that there is a protected zone that encompasses the conduct of married and unmarried persons, particularly with decisions regarding family planning, as the decision whether to bear or beget a child is a fundamental right. As such, the state action seeking to intervene in the right is subject to strict scrutiny. Given the overbreadth of the statute at issue, it can be presumed that it would fail to survive strict scrutiny, right? So you're allowed to have these conversations of whether you want to have kids or not, what you think should or should not happen in the privacy of your own home. You should be able to do that and just be fine and not have to worry about legal consequences. And we're talking about regular conversation here. And that's what they're bringing up is like, if we don't define exactly what coercion is, what intimidating is, then any conversation being had qualifies, if that's where we're going to go with this here. And that is problematic. Because even I don't really care what your opinions are about abortion. Put anything in there, anything you want to talk about. Yeah, that's not right. So more generally, suppose an individual electronically posts a statement indicating they are pro-choice on social media, and someone who greatly respects their opinion reads the statement and feels pressure to abort their pregnancy unbeknownst to the speaker. Under the statute, any person who comes across the statement and finds it to be intimidating or coercive could assert that they are a victim of abortion coercion. Do you see how this gets out of control very quickly, especially when you got crazy assholes like Laura running around who's just scared of everything all of the time because people looked at me.
Can it go the other way too? If someone tells you you can't get an abortion, yes. So is that pregnancy coercion?
I would agree so, yes.
So I feel like if you flip the statute, it should be able to, like, you can't force someone to
carry.
Can't force. Yeah.
Well, it's the same, like, let's say, for example, a woman is having a non-viable pregnancy. That's really where that argument comes in. If it's not viable and she's subject to die, like, you shouldn't be able to force someone to carry a dead fetus. You know what I mean? Like, that's part of that other side of the coin. You're right. Intimidating and coercing somebody to stay pregnant at risk of their life. So both sides here, it's problematic. We need to define these words more because, I mean, with everything, right? There are going to be extremists. There are going to be crazy assholes who misunderstand law, Laura. And there's numerous people like that. So it's very important that, we make sure that things are worded appropriately. And that's what they're arguing here. Again, the second half, really, this has nothing really to do with anything Laura said. I mean, yes, she went the abortion coercion route, but they're pointing out a really big problem here. And it is a problem for Greg in the sense that she's like, hey, I was intimidating and whatnot. So it does, but this is a problem with the statute itself. So, and it's complicated. All right. I'm not going to sit here and pretend I don't have answers for any of this. This is all very complex gray area, case by case thing. And that's what they're saying too, is that vagueness is not. Was I almost at the end here? I hit my keyboard and I missed.
I'm sorry. I
hit my keyboard. So
we get into a circular conversation, because I will peel back the layers on this and then it'll go off the chain and somewhere we didn't intend it to go.
Oh yeah, here we go. So without the ability to discern the meaning of the statute and exclude legitimate permissible conduct from its prohibition, the statute is void for overbreadth and unconstitutional. Wherefore, Greg hereby respectfully requests the following: that this court dismiss plaintiff's complaint with regards to the abortion coercion claim with prejudice pursuant to 12b6 and 12b7. In the alternative, that this court dismiss plaintiff's complaint on the grounds that ARS is unconstitutional. So they're asking to dismiss because Laura didn't bring a doctor into this and sue them too. And then they also want it dismissed because The statute seems kind of unconstitutional in this case for Greg. So
I would be interested to know where this is. Did it go to the Supreme Court? Because like I love I like to watch the Supreme Court hearings. They're so interesting.
Oh yeah.
So
because it's arguments like these of like, okay, let's use this whole thing and put it in a bunch of different scenarios and see again, is it more harmful than for the greater good? You know what I mean? And that's what they do all the time. And that is my favorite, the hypotheticals. But we're nerds like that. So
yeah,
now,
I'm such a dork.
They also asked that the court award Greg his attorney fees and cost, and that the court grant such other further relief as deemed appropriate.
I think he's being very generous there. He should be asking for pain and suffering.
And then here's him submitting the good faith certificate, that the judge called him out on for not filing before.
Oh, and here you go.
Oh yeah, I'll send it to Buff as well. So that's all we're really going to cover with that today. Stuff to think about there, and then we'll see what's decided on there. Quite honestly, I mean, based on what we read, I wouldn't understand why it wouldn't be dismissed without her bringing a medical provider into the thing. But again, I'm not a judge. But I do think they made very good arguments there against it. They're bringing the low. I mean, though, you hush. All right.
You let us know when you do that, because I want to follow that one.
You hush. Ohio is here. Yeah.
I need to know that file number, that case number.
For which? For what?
For when he files his lawsuit. Because I'm following that docket.
He does. He's Greg with 2 G's, which I love. I've never seen a Greg with 2 G's. I know that there are those, but I've never seen them. I wonder what their choice is. You know what? Let's put an extra G. Is it Greg? I don't understand the point of an extra G, but whatever. So I think that was really, interesting. Things they're arguing here. Obviously, we've read this several times, and I don't think Greg said anything that was intimidating or coercive. But Laura believes that it was. And that's what they're arguing, is that if is the person's belief outranking the reality of the situation? Because remember, Laura, you look at her, order of protection.
Pregnant.
She even thinks about order of protection, right?
Also pregnant.
Like, should we let people's beliefs of things? Because what's the other one where that happens a lot? And you're just like, okay, but it was the order, like when she got it renewed for Mike, all they asked Laura was like, she was like, well, I still believe I'm in danger, even though Mike had done nothing to violate his protection order in 2 years.
I saw him.
No, because she believed she was still in fear.
Yeah, and she said she thought she saw him, and he wasn't, like, there was no proof that he was actually there. She just thought she saw.
Nice. And that caused me a big problem with, okay, you can believe you are afraid of him, and that's fine.
But isn't that like the statute, or is that like the standard for a lot of these restraining orders, is that the person still has to feel like they're in fear? They don't necessarily have to be in fear or like be in danger. They still have to feel like they are in danger. I think we determined
that was California's law for like renewing it for like a 5 or a permanent one. I don't know if that's everywhere, I don't know. But I do believe when we got to that point that everyone was like, well, that's all they have to take into consideration. Or no. In the transcript we read, that's what the judge told Mike, if I recall, now that I think about it.
Yeah. That's what I'm saying. Like, that they only have to be able to say that they're afraid or they're still scared, not that they necessarily have a reason to be scared. That, they still have that feeling.
Yeah, I do not like that. Because listen, your beliefs, they really don't mean shit It doesn't make them real. You know what I mean? Like, you know, Laura can believe she's pregnant, but guess what? She's not. So I don't know. I feel like that's just not a great area. Yes, Tex. They feel that if somebody doesn't go after you, that it's working. And if they're caught going after you, that it's working, which is why it stays active in California. Yeah, it's total bullshit. And yes, they do. Like, what if you say it this way, though? You know? But, you know, lots of things. And listen, in some situations, yes, you know what I mean? But then you have people like this. Now, I'm not saying we need to upend the whole thing because some people abuse the system. Because that happens in literally all systems always and forever. Okay. Like, that's always going to happen. Always has and always will. There's nothing you can do about it. But I do feel like maybe they need to add an extra, because again, it affects people's lives, you know? So I don't know. I don't know about all that. Right? She felt like she was having boy and girl twins. Like, I don't want to live and be like have my life upended because of what Laura Owens fucking believes. Like, I do not want that dictated by that woman at all. At all. Look at what her beliefs have done to people. Her beliefs are dangerous, really. So
that's like me trying to explain this case to my oldest, who was in the chat the other day.
Oh yeah,
because she just popped in, and I was like, because she was stalking me, because I wasn't answering my phone fast enough.
Oh right.
Then and so I was trying to explain it to her, and she's like, but does she actually think that, you know, she is pregnant? Because like there are people that have like really believe that they are. And I had to be like, no girl. There's
she knows she's here. This isn't one of those delusions, which does happen.
Yeah, like the hysterical pregnancies.
Yeah,
stuff.
Like those are all very real things, but the evidence very much points to absolutely not. Nope. She just lies and makes stuff up on purpose, because you know that's there. The one that was in the chat the other day is 24. Where are the receipts at? What, our receipts or Laura's? I don't know. It's hard to have receipts on stuff that isn't real. So, you know, our receipts are the evidence that they submitted to the courts and we read, and it's pretty obvious. So
she manufactures her receipts, allegedly.
Yeah. Well, actually, that was proof. She has some charges over it. So
charges are not proof.
You know, like that's the man. This is about to get so crazy in this case. They're coming to play, and I can't wait to read what Laura's response is to that. Did she even read that and be like, "Oh, you know what? That makes sense"?
She didn't understand.
Like, I don't know what any of this means.
I guarantee you. Does she have to, I don't know, chat GPT a thing, stick it in there and have it like tell you, tell me like I'm 5.
Well, I did provide proof that P-tests, I've shown you, my doctor said I was pregnant. How is that not enough? Well, that has nothing to do with the abortion pills, ma'am. I showed you proof. I know, right? Doesn't she look fantastic? I mean, she's still young, but
it's a great.
She looks great. Like, girl, I started noticing gray coming in too. I was like, fuck, 40 sucks so much. I don't like it. So I can't wait to see how she comes in swinging on the next whatever she submits, because now she's stipulated to not go into the domestic violence criminal territory. And you know, I want to see how or does she get a lawyer by now? I don't know.
She has a lawyer. I thought she had a really cute lawyer.
No, not at this point. She's still representing
herself.
No,
I thought we were talking about the new law.
Oh, no. I mean, where we are in this timeline. She's still
I'm sorry. I was thinking ahead to like the trial coming up.
No. Yeah, she does have a lawyer for that.
When is her due date for her response to her? Is it like April something?
Yeah, April. I want to say 23rd, 25th. It's the end of
I really need to
April.
write that
Of
down.
whether or not she's going to take that plea deal or not. Which is the fun game we have. Is will she? Won't she? I don't think so. Honestly, I hope they take it away from her. And they're like, you know what? Never mind.
Look,
The 24th.
Chat knows. They have it circled on their calendar.
I was a day before and a day after. Oh, Amos is backstage, and she has a little surprise.
Oh my God!
What? What surprise?
A little surprise.
A pregnant Poe with a little tater tot.
I love me or else.
Wow.
Literally me through my entire pregnancy with all three. I'm pregnant. Now love me or else.
Love me or else. And that's fair.
I need love.
That's fair.
I need to be coddled.
That's very cute. Thank you, Amos, for that.
That was adorable. It's so funny.
And Poe's expecting a tater tot. Will it be twin tater tots? Stay tuned to find out. I'm just kidding. We're not going to do that to Poe. We love Poe, her little couch potato. So yeah, I'm excited to see where this goes. This is the part where I really don't know what's, I haven't read anything. So hold me like I'm pregnant.
Wait a minute. Did she say that?
Yes. Yes. I think she did say that in one of the texts that we've already read or something like that. It was in something. She went over there to stay. It was after weren't they supposed to be going to Sedonia or something like that? And she took the pill or whatever, and she asked him to like still do that or something. Is that the right part of the timeline? I don't know.
Okay, so different. It's Clayton.
Oh, she said it to Clayton. Oh, my apology.
Oh my.
She's nuts. That's right. We'll have to have a poll. Who's Tater Tot's daddy? That's what we want to know. We'll see.
Wow.
We'll see.
Tater Tot or Poe's got to go through LinkedIn, figure it out. Pick one.
Oh man, these guys, I just can't. Oh, I feel so bad for them. This is just crazy nonsense, one after another. And I can't believe that at this point the judge doesn't dismiss anything that we've read so far. I don't know much about civil court and that process of like how far things are allowed to go. You know, it is very, very different on expectations. So that was a really good argument.
Is there a response to that? Do we just get into that later?
I think so.
Hold on. Does the civil courts even respond to that at all? Does Laura respond to that? How does that even work?
Yeah, actually. Wait, no, that's motion to dismiss, motion for judgment pleadings. All right, so that's from the defense. So Thursday, what we'll be reading is plaintiff's motion to extend time to file a response to their motion for that. All right, so first up is Laura being like, I need more time.
Well, she doesn't even that. I was going to say, read. I don't know what that means.
I don't know what it says, but that's probably exactly what that is. Yeah. I'm not a lawyer. I'm representing myself, and they use a lot. I don't know what they're talking about.
They said a lot of big words.
A lot of big words. And it made too much sense, and I got to figure out how to make it not make sense. And then followed that, we'll be reading the response objection to plaintiff's motion to extend to file a response. Sorry. So Laura's motion for more time is 4 pages. The response and objection to her asking for more time is 22 pages from the defense. Oh man, I hope it's so good and snarky. And then she files a motion to extend time in response to the defendant.
Oh my God.
Motion. She responds back with 9 pages of why she deserves more time. And then response objection to plaintiff's second motion to and then she finally responds to their motion to dismiss. How long later?
This relationship is exhausting.
Oh, that's when she finally gets a lawyer.
Yeah, because she doesn't understand anything else. She was like, yeah.
She gets
This
a
is
lawyer
outside
for
of
that
my
one.
scope.
Oh my gosh. She's like, I don't know. This is all not looking great for me. Let me hire somebody finally. So it looks like that's probably going to be hilarious. So watch them argue why she doesn't deserve more time. I feel like there's going to be some snark in there. So that's what we'll be getting into Thursday and Friday. So it'll be a good time. Then we're going to have, after we cover the next several things, then you guys, we're going to get into some Zoom hearings, and one's an hour long. I'm very excited to see some things actually playing out in court. So that is where we're leaving you off. She goes through several lawyers in this civil case as well. Yeah, that is one thing I noticed when I was putting together like the documents and stuff. Was I noticed that the deadline would be coming up. So she would hire a lawyer to extend the time, have them write an actual like professional thing. And then within the same week, get rid of them and go back to representing herself. And then the next time something is important to do, she's not given more time, she doesn't know how it works, she hires a different one and then gets rid of them in the next week. The game, it's so crazy. It's so crazy. It looked like it was a few before she got to Gingras or whatever the fuck his name is.
Gingras.
Yeah. And I think she goes through like 2 or 3 of them, if I recall. I think you're right about that. It was a few that I was just like, girl, who are you trying to fool here? But we'll get into that. So.
Who they called Dingus? I think I saw that in our comments. It's like, I think we just call him Dingus. And I'm like, I feel like that tracks, actually.
They have lots of names for them, and they're all great. They're all great. Trust me, y'all. I have read some of the things that he's submitted, and I can't wait to get wild.
Like, it sounds like he is like the gasoline on her fire.
Oh my gosh, yes. He's so fucking petty. He's so ridiculous. You thought the crazy shit Laura said in her stuff. This is a lawyer saying the stuff he does, and it is amazing. Amazing. And then that seems to get Woodnick real fire. I mean, it's ludicrous. So it is like when oil and gasoline mix is those two. So
yeah,
I can't wait.
Dumpster fire, but I also like it when it's in court.
Right. Douche canoe. That's one of my favorite words too. All right, you guys. Well, listen, that's all we've got today. Oh, thank you. Well, you come back, Miss Baby Queen. We're doing this Tuesday, Thursday, and Fridays at 11 a.m. Eastern. Buffy won't be here Thursday, but the lovely Terry True Crime will be with me.
I can be here Thursday. I just have to be out by a certain time.
Whatever, you can join me and Terry, or you can, whatever works for you, babe.
We will never get anything done if me and Terry start talking.
That's true.
I'll pop in.
That's fine. And then we'll be here Friday at 11 a.m. as well to continue our journey. I will say in April, there's a few Fridays I can't because of Mama Llama stuff I have to deal with my little Llama. So
it's getting to the end of the school year, so that does get hectic.
Oh, well, he's going to, speaking of Arizona, he's going there for spring break. And so his flights are on Fridays in the middle of, so, preparing to get him going. And then on his way back, I'm just going to be, a wreck all day. So I canceled my shows on both those Fridays in April because I was like, let's be honest. It's not going to happen.
Oh, we can create a distraction for you.
Well, no, he gets in.
Oh, okay. I was thinking that you were going to be like all nervous.
Well, I'd be nervous in the first part. Then I'd have to leave. Then he comes back, and I want to talk to him about stuff.
Gotcha.
And then the first Friday, it's packing to make sure he's ready to go. Because I would love to think that I get things done ahead of time. I love that, but that's not how that day is going to go. So let's just be honest with that.
Thanks for being honest with ourselves.
Yes, baby Llama. I mean, he's 14, but yes, he's very safe and he's such a good kid. But when you're only one, you worry about everything all of the time. So, but all right, you guys. Well, thank you so much for being with us today. You have anything to say then, Buff, before we sign off?
I don't know how y'all put up with me. I'm just That's the only thing I got to say. I don't know why y'all still listen to us talk.
And you're
or listen to me talk.
I love you and your
I just talk. Is this
well,
I just ramble.
Speaking of, if you guys love sass, me and Terry have been covering on True Crime and Wine Time the Robert Hansen story. He's a serial killer. We're doing a multi-part series, and you may know who Robert Hansen is, and you may know of what he did. All right, killing 17 women in a short period of time in the 80s. But what you may not know is the 14 years leading up to that, when he could have been put away numerous times. It's infuriating. With each and every episode, it gets worse and worse. There's so many rants and cursey words because it's truly inconceivable how any of this was able to happen. We have strong opinions about the state of Alaska because it's still going on to this day of all of that. So if you haven't, we do have a playlist. We have another episode tomorrow night at 8 p.m. and Thursday at 8 p.m. as we continue our coverage on that. It is one of those things that went from one episode to like 10 because I was just like, we have to talk about all of this because it's just unbelievable. So yeah, not the Mbop Hansen.
What part is coming up? This is 6 tomorrow.
Yes, tomorrow's 6. Okay. We're in the middle of the 70s. We haven't even made it to his crimes yet. Well, we have covered some of his crimes, yes, but to the ones that most people are aware of and familiar with, we haven't even gotten to them yet. Those come next week. But it's truly unbelievable. And there's plenty of victims before then, and victims that I believe are his that were never accounted to him. So anyway, there's that to watch while you wait for us to come back.
You wait. So.
Or if you love Marvel, please join our Discord because we are doing a Marvel marathon in preparation for Doomsday. We're finishing up season 1 of Agent Carter today because I'm a nerd, and season 1 of Agent Carter, and from there. So join our Discord and have fun. We can talk true crime too. You can talk Marvel if you love that. We're going to be doing lots of cool new things too over on that Discord here soon. So join that if you miss us while we're off or there. So.
New series.
Llama rants about everything.
We'll just change the name of this stream to Let's Rant About.
Right. You can find our Discord in the chat. I'm sure one of the mods will drop that. I think it's in the description, and it's definitely in our About page. The Courtyard is what it's called. So come join in. If you don't know how to use Discord, we'll help you out. It's fine. We're all new once, so we love new people in there. But all right, friends, enough of that. You all have a wonderful rest of the day. And until next time, go forth and be amazing. All right?
Bye.
Bye.